But they kind of switched our laptops to where only IT can do it. That's where you did the screen thing, huh? Just keep hitting the mouse key, yeah. I think it's the mask.
I think it's the mask. All that hot air on your face.
And I've been talking a lot.
Oh, that's hilarious.
Your mic's on. Like, oh no.
Hey, Ted, do you know the meeting password? Joel just texted me.
She should. They were
I
just
don't.
telling me that each person has their own.
Oh.
Well, I do.
Oh.
But the password to get in should have been in the email, right? Is that right? That's what I understand. Erica's asking
That was
for
my
it as well.
understanding. Erica's asking as well.
I'm the worst Zoom person, invitee, attendee. I'm terrible at it. I don't understand it at all. Let me check.
They should be able to just click on join and then change the name to their name.
Oh, interesting. Okay.
Isn't that what Matt said, Ted? They can click on the email I sent out. I sent it to Devin just today. And I think you got it too, didn't you, Cindy?
I'm checking right now. See what.
So there's no password that they should have to enter?
Well, Celine's instructions said don't click on password. Except for you and Josh.
What I have is 277398.
Okay.
See if that works.
27739.
What it shows in the Zoom account. If I go
Cool.
to this
Okay.
webinar.
Thank you.
Is that the same one I gave you, Ted?
What was it? 277398?
I don't see one on
I think
here.
it's like embedded in that link that gets sent.
Well, Matt said what happens is when I hit save and it emails them a thing
It sends them that
of their
link.
own.
And that's like their own.
Oh, it's
I
like
didn't know
participant
this,
ID. Is that what it is? Because mine is different.
Yeah, see, I think you guys each have your own.
Oh,
She may come in
interesting.
As a different name,
Okay.
and we may have to change it.
I'll
which is
text her.
fine. I can adjust her name.
Danielle's asking as well.
Yeah,
she
I
can
think
join
it's
on-
in the email.
there
Oh,
she
there
is.
she is.
Oh, she came in
Yeah,
as
she
me.
came in as you, so I'll change.
Oh.
I will change her.
And Matt was telling me tonight that I can set those up ahead of time and wait to send that.
Oh, interesting.
Okay.
Don't type in the email addresses until a couple days before.
Okay.
And I didn't know that in Celine's
And just save
instructions.
it.
It says do all of it.
Okay.
But
Yeah.
then they get it like a month ahead of time.
Okay.
And they lose it, understandably so.
Or check the email yours.
And do you have her name, Josh? It's Jillian Maroney.
Okay.
It's J-I-L-L-I-N.
Oh, Tucker. I love him.
M-O-R. Yeah. He's
I
cute.
cannot believe how big he is already. It's insane.
Right, he's getting huge.
Oh, Tucker.
Look like
Oh
you're
my
coming-
gosh.
Looks like you're logging in.
Hi. Oh my gosh, I love seeing babies.
He's the cutest. He looks just like Reed.
Now Noah's asking about a password.
Oh no. It seems like it's just in that email, whatever email they got, it's the participant link at the very, or participant ID at the very bottom of the email.
I tried the number. Can you guys hear me okay? This is Erica.
Yes.
Okay. Yeah, thanks, Ted, for the number. I couldn't find it on the bottom either. And I tried some of the ones. It was like, try this passcode. And I was like, oh, that's not working.
I can rename
Yeah.
that too.
There's Mary Grant. She got in okay.
Oh, great.
So is everybody logging in as Nikki?
It's looking that way. Mary didn't. Mary's right on point there.
Amazing.
I'll kind of fix them as they come in.
Do we
We
have,
didn't have this trouble last month, did we?
are we just missing Noah
Devin?
and Devin?
I mean, we don't,
And
I
Danielle.
don't think we
Danielle
technically,
should be.
Oh, is she? I didn't see she was coming.
we
Great.
don't technically,
Caroline is the only one that declined.
Right.
oh, Danielle,
Is she having trouble too?
yeah.
We didn't have trouble last month, did we?
Mm-mm.
She said she tried the webinar ID and
It's a new
participated.
wrinkle.
What's
Is
the,
that what it is? Is that?
It's this password thing.
So, yeah, so Josh, should I be sending that password to them too?
I don't think so, because
Because Celine said just you and Ted.
I thought it should be embedded in their link. 'Cause
So-
they're coming in as you because
Yeah,
it's using,
Weird.
I think, I don't know, because you set the thing up, so it's
and I
using
set
your
up
password.
last month's HPC and didn't have any issue.
We're gonna have to play around with it a little bit this next month and see what's
Okay.
going on.
Did we lose everybody?
I'm just gonna have them, yeah, Devin can't get in either.
Oopsie.
Yeah, just have them use that same password and we'll fix their name.
Sorry about that.
Technology.
I wonder if it was because I entered the password after I created it, Josh.
Maybe. Yeah, that might be it actually.
Because I created it and then we got that information from Celine. So Melanie and I went back in and added the password after the fact.
We'll run a couple tests this next week. We'll do a couple fake ones and try and create this password.
Hi, how are you?
Hi.
I am. I will. Good to see you.
I didn't recognize her.
I know,
first
I
with
didn't-
her
I didn't
mask.
even-
thought,
I didn't either.
"Who is
We
that?"
ran into
I
her.
didn't see that far either.
We ran into her and
Then I
Scott.
realized, oh, that's the mayor.
We ran into her and Scott downtown a couple nights ago at like dinner time. And their daughter used to babysit Leo
Oh,
before she
really?
went away to college.
Uh-huh.
And so he just loves them. He was so happy to see her. It was so cute.
Thanks for taking care of that, Josh.
Oh yeah, no problem. Danielle works at CSH2A, right?
I'm sorry, what's that, Josh?
Danielle works at CSH2A, right?
Yeah.
I think
Yeah, that's
so.
probably her with the CSH.
Yeah, she works with James Marsh.
That's.
Her last name's Weaver.
One, two, three.
And then Noah Ritter. And do you know how to spell his last name? Rrchter.
Ted sent me over the password, or it seemed to work out. So thank you, Ted.
Yeah, we're having some technical difficulties. You all are logging in as Nikki now, and we have to change.
Thanks for the password, Ted. This is Devin.
Oh, you bet.
Jill says that she can't hear anything. It sounds like when you guys changed the name, it stopped her audio. Yeah, she just said, should I leave and come back?
That's probably good, yeah.
She said, I also have a crying baby, so there's that. Love it.
Looks like everybody's in.
Great.
Did Jillian go back out and back in already?
I don't think so.
Oh, I like Kevin's background.
Ready? Should we go ahead and get started? Yeah, okay, great. Let's go ahead and call the work session to order. Ted, go ahead and take it away.
Okay, thank you, Madam Chair. We have a short work session presentation, but I'll open up by going through the agenda real quick and identify the items, how we're going to handle some of these items or propose to handle them. Item number one is DRH 2150. That's the one that was deferred from last month. We will definitely be hearing that one. Item number two is DRH 2231, a certificate of appropriateness to construct a garage and ADU. That one will be heard as well. The applicant will be giving a presentation on that. Item number three was deferred. The applicant needed more time to work out some kinks on this application. So that's DRH 2278, proposed to be deferred to August 31st. Item number four, DRH 2282. This one was deferred because the applicant just didn't get the site posted in time. So by state law, we had to defer that out. And our only item for consent is item number five, DRH 2290, which is a certificate of appropriate request to construct a 1.5-story garage with an ADU on top. Any questions or comments on those? Okay. So we will move on from the agenda and I will share my screen. Let's see. Hopefully this will work okay. Can everybody see my screen okay? Anybody not see it? Okay.
I see it.
Okay. All right, so we'll go ahead and proceed. So this, some information has come in and different comments have been made. So we just wanted to go over, the process of demolition and the role that the commission plays in that process of demolition of historic buildings in a historic district or otherwise historic buildings in the city. We did, in response to some of this information that we've received, our city attorney's office, Mary, who's representing historic preservation for the city attorney's office, put together some language, which I will go through part of that in the work session and then part of that in the actual hearing portion of the evening. But the role of the commission under city code, exacting punishment for violations of the code is not within the purview or authority granted to the commission. While it is the duty of the commission to promote, preserve, and protect historic assets, it's the city attorney's office and the department who is supposed to proceed with those kind of actions. And again, underlined there, legal strongly cautions the commission that any decision on the application made for the implicit or explicit purpose to punish the applicant would likely be the subject of an appeal. So the commission, their role with these demolitions are to review proposals for demolition of historic structures and structures located within the boundaries of a local historic district, and hold a public hearing for demolition of contributing structures or structures with local landmark status or historic easements owned by the city, and to make a decision on those, on those demolitions, to either approve the demolition or to deny the demolition. And you'll see below that the findings. In order for the commission to approve a demolition or relocation request, at least 3 out of those 5 findings must be met. And so you're very familiar with those. Those are in your packets for demolition proposals and explanations as to whether the applicant actually meets any of these or one or more of these findings is explained in those packets. One thing, a lot of what we hear is that there's a lot of confusion and gray out there on what can be done to a building, what is demolition, can you deconstruct? We've heard this, we've talked about this, the contractors and property owners tell us that we're not clear sometimes in what we do. And so we kind of try to massage out our reports and our conditions and ultimately our code and our guidelines. And this is a condition that we've started using here. And this is something you probably won't see this time, but next month you'll see it in one of the packets. But the commission is essentially, as it states, this permit does not allow any portion of the house to be demolished. The entire structure, including foundation, exterior walls, and roof, shall be retained and protected. And then it goes on, failure to comply will result in issuance of a stop work order, and property will stop until approval by a historic commission or appeal from the city council. And again, this is just our attempt to try to pull out some of that gray, make things a little more clear for the applicants and the public in general, that when we are approving a house for a new basement or an addition, that we're not approving the house being deconstructed or torn down and put back together the way it was before. That's not something that is appropriate, and it's not something that we approve with any of our applications unless it's requested and approved by the commission. And so as we move forward, and again, we work closely with legal to make sure that we are working within the parameters of as we move forward and consider ways to make the process less gray and to even codify some of the penalties, as you'll see here, which we do not yet have, but these are some language that we've discussed in our office of what possible penalties could occur if it was laid out more clear in our code. One that is fairly common if you look at historic districts across the country is a construction delay. And that delay can go anywhere from, I've seen 6 months to 5 years, a delay on new construction on that property if you illegally demolish a historic house or building. And then another one, which is also technically a delay, is requiring any illegal demolition has to go all the way through to city council for final approval, not just the Historic Preservation Commission. This not only not only implements a delay of a couple of months, but it also puts it in front of the mayor and city council so that they are aware of what's going on. So they see firsthand and can make comment and be on the record for these items that are being illegally demolished. And I'll just say we don't see a lot of these. And that's why this one, the ones that we've seen recently have kind of, we've had to kind of step back and kind of, frame ourselves a little bit with what we can do, what's in the code, et cetera. And moving forward, though the commission doesn't implement penalties on these projects, we certainly want the commission to be a part of, the discussion on what the city should be doing as far as penalties for these illegal demolitions. So, and again, working within the parameters of what our legal department thinks is appropriate as well. So it would be a kind of a broad discussion, but moving forward, what can that look like? What are some of the penalties that we should be implementing for these kind of activities? And that's all I have on that. It was just, I just wanted to give a brief kind of outline of what we're looking at as we move forward. Like I said, we don't see a lot of these illegal demolitions. At least we don't know about them always. And so when we do and they come before us, there is a process and the city has certain routes that they have to take with that process, and so does the commission. So with that, I'll just open it up for discussion. If you guys have any questions or comments on this. And again, this work session isn't to talk specifically about any particular application. It's to talk about illegal demolition and the role of the commission and the role of the city.
Madam Chair, Ted, this is Commissioner Koski. I guess my first question is if we, as a city, have a process for this, and my understanding is if there's been a violation, the process starts with a stop work order. What process do we have to pull it off of a stop work order, since that came from code enforcement? What's the next step? And I guess maybe that's more a question for legal. I think Mary, I guess I should say welcome if you're there, since you're our new person.
Hello, all. Yes, I haven't had an opportunity to introduce myself in person given the current situation, but I've taken over for Adam, who used to be present with you all from our office. To answer your question, Commissioner Koski, the stop work order is placed with a condition that the applicant go through the proper procedures and steps to get approval. So at this point in time, we have initiated that for the purpose of ensuring no additional work happens in discussions with staff of the planning and the historic offices. We have determined that as far as what our abilities are under code right now, time is the biggest penalty. And as these construction sites lose time, they are losing money, and that is likely a more effective remedy at this point than a small fine for a charge of a misdemeanor. There is a possibility of going down that route. However, to get more to the point of your question, once they have gone through and gotten the appropriate certificate of appropriateness, they have gone through the procedure, then that work order or the stop work order will be lifted so that they can continue with approval.
Okay, so the city, the code enforcement office can't take off of a stop work order. It has to go through the approval of whatever process is for to get the certificate of appropriateness, which means it starts with HPC. It sounds like.
I wouldn't put it that way. What it is that this is a condition placed by the department on to the applicant that once the appropriate certificate of appropriateness has been received, then they will remove the condition. Unless and until that happens, the condition will remain. And so the punishment, so to speak, is not with HPC, but it is conditioned upon what happens next with this particular application.
Okay, thank you.
Are there any other questions for?
Yeah, Madam Chair, this is no Commissioner Richter. This is probably a question for Mary as well. If we were to defer this application to reclassify, so there would be an opportunity to repost for public comment. Our next commission hearing, I believe, is like 63 days. Would we need to get approval from the applicant that 63 days is okay? Can we even ask that of the applicant? Or is that 60 days like a hard stop, and there would possibly be a request for a special hearing in order to fall within that time constraint that we're under?
The 60 days is a hard stop unless we get agreement from the applicant. So yes, you certainly are welcome to get agreement from the applicant and to ask him for that. And that ask can come from staff or from the commission. And if the applicant were to agree to that 3-day extension, the commission could make that decision at the next hearing. If the applicant does not agree, but the commission would still opt to hold a public hearing for reclassification, I do believe it would require a special meeting in order to meet that 60-day requirement.
Okay, thank you.
Any additional questions? I do have one. What type of outreach is going to be done, or is there any going to be done to ensure that the public is aware of these penalties moving forward? Like, is an applicant made aware of potential penalties upfront when they're submitting an application, or is there going to be any type of like mailer outreach or something like that?
Madam Chair, members of the commission, as we go through a process of identifying particular penalties, a penalty or particular penalties for inappropriate activity, that would have to be approved if we were going to codify it, or even if we weren't really, it would need to be approved by the city council. So it would be first a public hearing in front of the Historic Preservation Commission, which would be broadly noticed, and then another actual public hearing for a final decision on that code amendment or code addition by the city council. So the process of implementing it would be, we'd probably, for something like that, make sure we did extra outreach to, all stakeholders, very broad outreach to maybe even the BCA and other organizations that need to educate their members on things like this. So we would do a very, very broad outreach on that. And as far as ongoing, it would be language, if whatever language we did implement would then would be integrated into our staff reports as well. So they would have that awareness as well. Yeah, so we would do our best to get that information out and let people know what the consequences are of that inappropriate activity.
Fantastic. Thank you. Any other questions for Ted or for Mary?
Yes, Commissioner Koski, as far as deferring well, let me not deferring. If we are going to hear an item for reclassification, we've done that before, and we would go by the guidelines that we have for determining reclassification. That would it be fair to say that if there was activity on that property previous to the reclassification hearing, those activities would they affect a reclassification vote? For instance, if we had one property a few hearings ago, I think it was on 27th Street maybe, in Irene, somewhere around there, that we reclassified because renovations had been made to it so many times previously that it was no longer contributing property. But if it was a hearing on reclassification from contributing to non-contributing based on an illegal act, if something like that happened, would that affect the reclassification process? I don't know if I'm clear. I hope I am.
Mary, do you have a comment on that?
Sure. Chair and Commissioner Koski, I don't believe that. Let me figure out. I'm going to step back and I'm going to try to reframe that. The considerations for reclassification, whether from contributing to non-contributing or non-contributing to contributing, are laid out for the commission. I can pull those up if necessary to provide the exact language, but I believe that the decision would need to be based on those two criteria and not whether the alterations or changes to the property were the result of an illegal act. That specific aspect is not laid out in the criteria. So if I'm answering your question, Commissioner Koski, I believe that this commission would still need to look to the two criteria laid out as far as consideration of whether or not the reclassification is appropriate within the commission's discretion.
Okay, great. I think I didn't have the right words when I stated it, but maybe the right words would be current state. If the hearing is for reclassification, it's based on current state, not anything before that. So I believe that's what you just said. So thank you.
Yes, Chairman Commissioner Koski, that would be my statement. It would be based on current state.
And I would just add that most of the time you're going to hear 2 reclassification requests, I think, next month. But usually when we get these requests, it is somebody, or the property owner, requesting to have their property changed to non-contributing, due to that the survey was an error, or that work had been done that would essentially make the house non-contributing. So in cases where there's not a house left, for instance, to evaluate, I mean, obviously it's a different situation that we'll talk a little bit more about in the actual hearing portion of this property, or of this topic. So.
Hey, Ted's Commissioner Richter, Madam Chair. The current application that we're going to be hearing tonight, that's just for the the C of A to construct the house as designed before, have they in that application asked for a condition of reclassification on this property, or is this something that we're just having to do because our hand is forced at this point?
Madam Chair, Commissioner Richter, I mean, there's no requirement to do, and again, we shouldn't be talking about a specific application at the work session, but in theory, you know, there's, you know, in situations where a house has been demolished, there's not necessarily a requirement that a hearing be held to reclassify a property to non-contributing if a contributing home, for instance, was demolished. You know, there would, and again, we can talk more about this in the hearing, but the house is gone, and so it's kind of, you know, implicit that the property is non-contributing. So if the commission determined that they wanted to have that hearing, that extra hearing for reclassification, it would more be a formality in this case, in a case such as that. But it's not something that the commission is forced to. It's a part of code that maybe Mary can talk about a little bit more. Isn't, again, a requirement that the commission do, but it is an option. And in a situation where a house has been completely demolished, again, it would just act as a formality at best, because there's no way to really require that they keep the property contributing. So it's, you know, it's a bit confusing.
Yeah, so thank you, Ted. I appreciate that. So Mary, if let's say a house was demolished that was contributing, and the commission were to come back with a ruling that the applicant needs to apply for reclassification of the property, would that fall within the 60-day time constraint, or would that be something completely outside of it?
Madam Chair, Commissioner Richter, when a reclassification comes up, the code section is 110509, and it's under section 7. And under that section, that motion to reclassify can be made by the commission, by the staff, or by the applicant. So if the commission were to want, in its discretion, to have a reclassification hearing, that motion can be made by the commission itself, rather than having an applicant go back and reapply or to file for that motion or that reclassification. So I hope I'm answering your question in the sense that the commission would not have to send it back to the applicant, so to speak. That is a motion the commission can make on its own. In looking at whether or not that affects a deferral, it's related in the sense that from the first time the application is deferred, a final decision needs to be made on that within 60 days. So if there is a motion to reclassify, we have to give proper public notice for any hearing to reclassify, and a decision on that application, if it's related to that same reclassification, would still need to occur within the 60 days unless there was an agreement by the applicant otherwise. And then, so hopefully that answers your question. And then just to get back to clarification on a question by Commissioner Koski, when you're looking at the criteria for changes in classification, the true criteria for the commission to consider are: number one, whether or not the building, site, structure, or object is eligible for the National Register of Historic Places, and number two, whether or not the building, site, structure, or object contributes to the district. So again, that would be present state of how the commission were to make that decision to reclassify.
Great, thank you. That did answer my question. I appreciate it. Thank you.
Thank you.
Okay, well, thank you, everybody. And with that, we'll go ahead and call the work session. It is 5:54. Do we need to open a new Zoom thing, or is the public joining this?
Madam Chair, no, this is all part of the same. We just flow right
Fantastic.
into the public hearing. So we would
Wonderful.
stay on your Zoom until the actual meeting starts. So there's no need to re-log in or do anything.
Fantastic.
Hi. Hi. Oh, yeah, hi.
Did you get my email with the file, or do you want to?
Yeah, I have the file. Sorry, I forgot to respond. Yeah, I have it up. So
Okay, that'll be easier to kind of.
yeah, we don't have that. Normally you would testify at that laptop, but it's not really set up yet to interact with all this. So yeah, so
You just, I'll just stay next slide.
yeah, that'll work.
I'll just freeze through.
Yeah. Yeah.
Hey, Ted, are you still there?
Yes.
Or maybe Cody or whoever's monitoring. There are people trying to get in the meeting that can't get in on their link, and they need passwords. So I know there are a couple that I'm aware of. So I don't know how you want to do that, but maybe it might take a minute to get everyone on.
Direct them to that virtual meeting.
Are these members of the public wanting to testify? Do you know?
I do know a representative from Nina is trying to get on and can't.
Oh, okay.
Yeah, have them go to that virtual meetings page on the website.
Okay.
Boise.org/.
Okay. I'm not sure how to get it to him though.
I love these virtual meetings. I look forward to the time we're all back together, guys and girls.
No kidding.
I'll try to send that link to Nina. Here.
Oh, it
Oh,
says
Sherry's
we
in.
are on. Sherry is in and
Okay.
Mark
Okay.
Baltes.
Yeah, I was just gonna.
Oh,
direct
Sherry's in?
Sherry's
Okay.
in.
I was just about to send her the
If
link.
Devin's in contact with them, maybe you could direct them to that
Yeah.
virtual meetings page would be the only thing I would say.
Yeah, I was just about to email it to her, but if she's in, good.
Great.
Do we,
Thanks, Cody. Thanks, guys, for helping them out.
the applicant can
They're both in.
Steve and Karen both in.
Great.
Derek Hurd's in, Stephanie Dawson,
Excellent.
Brian Ernst, Derek Belville, email there.
Great.
Okay.
Ready to rock and roll. Do you need me to start, Ted?
Yeah. Good evening and welcome to this hybrid meeting of the Boise City Historic Preservation Commission. A few things to start out with for the good of the order. Everyone from the public entering this hearing virtually has been automatically muted and cannot speak. As the item you're interested in comes up for discussion, you will be called upon and unmuted. We will ask if you have slides to share, or if you can use the planner slides for your visuals. If you have your own slides, you'll be promoted to a panelist. This may log you off for a moment and log you back in, and then you'll have the capabilities to share your screen. A quick overview for Zoom. The capabilities and options are different depending on which device you're using. If you're on a smartphone, you'll be limited to only speaking and sharing your camera. If you're on a computer, you can share your webcam or your screen when called upon. Some laptops might not have microphone capabilities. If you wish to speak over the phone but watch on your computer, the phone number for this hearing is listed on the email you received when registering for tonight's hearing. For both smartphone and computer participation, there are controls on the bottom of Zoom to virtually raise your hand when you wish to speak on the item you're interested in. If you're attending on the phone with no visual capabilities, you can raise your hand virtually by typing *9. There is a chat function in Zoom that is part of the record and should only be used if technical difficulties arise. If the chat function isn't available for you, you can email zoninginfo@cityofboise.org with any technical issues. Our procedures for public hearings begin with a presentation from the planning team, and then we'll go to the applicant and then the representative of the Registered Neighborhood Association, followed by questions from the commission. After that, we proceed to public testimony, starting with those who signed up on the electronic sign-up sheet in advance, and then everyone else who raises their hand virtually. Each member of the public is allowed up to 3 minutes for testimony. We will provide a 30-second warning and then stop you at 3 minutes. We are strict with this time as it is limited in code. Then the applicant is allowed 5 minutes for rebuttal, after which the hearing will be closed and the commission will deliberate and render a decision. Tonight's agenda and proceedings will be almost the same as our regular hearing, except we might have a bit of a delay as we work through this new technology. Madam Chair, you have the floor.
Thank you, Ted. Today is the 27th of July. I'm Chairperson Montoto, and I now call the meeting to order. Victoria, would you please call the roll?
Montoto,
Here.
Rupp,
Here.
Weaver,
Here.
Richter,
Here.
Valderrama, Maroney,
Here.
Koski,
Here.
6 present, 1 absent.
Thank you. Have all the commission members had a chance to review the minutes from June 29th? Great. Does anyone have any comments or changes to the minutes? Okay, hearing none, I'm going to place item A, the minutes of our June 29th meeting on the consent agenda. And before we move to the consent agenda, we do have 2 items up for deferral. And that is item number 3, DRH 20-00278, Merlin Stark at 1109 East Warm Springs Avenue. Is there any member of the public wishing to speak on this item? Okay, seeing none, we will go ahead and defer item number 3. And the next item we have is item number 4, DRH 20-00282, Todd Heist at 714 East McKinley Street. Was there any member of the public wishing to speak on this item? Okay, great. I will take a motion on deferrals.
Madam Chair, I'd like to move to approve the deferrals of item number 3 and number 4 for tonight's hearing.
To the August, do we
To
have a,
to the August 29th hearing.
great,
August
Second that.
31st.
August
My
31st.
apologies, August 31st hearing.
Great, thank you. Do I have a second?
I'll second.
Fantastic. Victoria, would you please call the roll?
Montoto,
Aye.
Rupp,
Aye.
Koski,
Aye.
Maroney,
Aye.
Weaver,
Aye.
Richter,
Aye.
all in favor, motion carries.
Thank you. Moving to our consent agenda, we did place item A, the minutes from our June 29th meeting on the consent agenda. And our next item is item number 5, DRH 20-00290, Dan and Stephanie Dawson at 907 North 17th Street. Is the applicant present? Please virtually raise your hand. Great. I'm seeing a hand raised by Amy Allgaier. Are you in agreement with the terms of conditions in the staff report? Please virtually raise your hand again. Great. I'm seeing a hand raised again by Amy Allgaier. Is there anyone present wishing to testify in opposition to this item? If so, please virtually raise your hand. I see no hands raised. So with that, we will go ahead and put item number 5, DRH 20-00290 on the consent agenda. And with that, I move that the consent agenda and all items on the consent agenda be approved subject to all the findings and conclusions and conditions of approval agreed upon for each application. Do I have a second?
Madam Chair, I'll second.
Thank you. Victoria, would you please call the roll?
Montoto,
Aye.
Rupp,
Aye.
Weaver,
Aye.
Richter,
Aye.
Maroney,
Aye.
Koski.
Aye.
All in favor, motion carries.
Fantastic. And we will now move to the remaining items on our agenda. The first item to be heard this evening is item number 1, DRH 20-00150, Ken Litzinger at 1521 North 5th Street. This is a certificate of appropriateness request to construct a partial 2-story single-family structure and associated site improvements in an R-1CH. Ted, may we please have the report?
Thank you, Madam Chair. We'll go ahead and share my screen. So, Madam Chair, members of the commission, good evening. This is an application to construct a partial 2-story single-family structure with associated site improvements. Was deferred from the from the June hearing. I'm just going to quickly, you have your packet. We've been through a lot of the plans and photos of the building, so I'll go through that a little bit quicker and kind of get to the meat of the discussion. This is the house that was previously standing on the property prior to it being demolished. This is the lot on the corner of 5th and Sherman. And this is the site plan. Again, these plans were previously approved for the house that did exist on the property as an extensive remodel. Was approved in 2017 by the commission. And these are some elevations. Interior and rear elevation, and then the front and street side elevations. So just a quick background, excuse me. As I mentioned in 2017, the commission approved an extensive remodel to the contributing home on the property. In March of 2020, staff was called by a neighbor that the house had been demolished. Upon confirming this, a stop work order was placed on the property, and then the applicant on May 8th submitted plans, essentially the same plans for the extensive remodel. They were now using those plans for new construction. On June 29th, the commission reviewed the request and deferred the application to the July 27th, 2020 commission meeting. At the hearing, the commission expressed concern that the contributing house was demolished without the required approvals or permits. the commission asks that staff return with information on demolition and how the city handles illegal demolition in the historic districts and how the city may plan to prevent this from occurring in the future. You saw this in the work session, so I'll just bring it up here in the actual hearing for the record. This is a condition that we are starting to add on applications to remove some of the gray out there. We do get feedback from the public, from contractors, homeowners, that, you know, our process isn't black and white enough. It's hard to understand what's allowed, what's not allowed. And so we massage these out to try to make things more clear. And so we sometimes will change our conditions or add conditions like we've done in the past to try to make things more clear on what's expected and what is inappropriate. And we also went over these in the work session. Again, and maybe down the road, the commission, a work session can be set up with the commission to look at our code, look at what we have in there, and look what we could do better as far as penalties for illegal demolition of our historic resources. So again, construction delay is what a lot of cities across the country use to discourage illegal demolition. And those range broadly on how much of a delay. We've talked about that a bit just between staff on what that would look like. And then another item that we've talked about is requiring a city council approval for any new construction on an illegally demolished property. This would implement a process delay of a couple of months, and it would put that issue right in front of the city council. So the commission may recommend amendments or additions to city code concerning penalties for illegal demolitions. The proposals would require a public hearing by the commission and final approval by city council. So whatever the commission may determine through a work session would be appropriate. That would have to be, of course, our legal office would be involved, and city council would be the final approval on that process. Excuse me. So on this application, you did receive a letter from the North End Neighborhood Association and an attorney representing the North End Neighborhood Association asking about further action on this property and for the applicant. Nina has indicated, as you see there, a desire for the commission to hold the application until appropriate consequences are levied. And again, under city code, it is not the role of the commission to, impose penalties or, exact punishment upon an applicant. Rather, it is certainly the duty of the commission to promote, preserve, and protect our historic buildings and resources. However, the penalties and whatever action is going to be taken would be taken through the department and the city attorney's office. And again, the underlying portion is legal strongly cautions the commission that any decision on this application made for the implicit or explicit purpose to punish the applicant would likely be the subject of an appeal. And further, you see the third point below, a deferral on an application must comply with Boise City Code. Without agreement by the applicant to the deferral, a decision must be made by the commission within 60 days of the initial hearing date. And this is the second part of the letter from Nina's counsel, as they urge that a reclassification of this site from contributing to non-contributing must take place, or the application must be denied. So as you've had a chance to read the memo, the city takes the position that such reclassification is discretionary providing the commission with 3 options for its decision with regard to the application. The commission may decline any action to reclassify the property. And the advantages there, there's advantages and disadvantages you'll see in the memo and down below. The advantage of declining any action to reclassify provides efficiency in the procedure and protects the due process rights of the applicant. The disadvantage would be a potential appeal from NENA to City Council, though that may be difficult to show that lack of such a hearing violated a substantial right of NENA or its members. Next, the commission may defer the decision on this application to hold a hearing on a motion to reclassify the property. Due to the required notice requirements under 1159, should the commission decide to have a hearing to reclassify, the decision to approve or deny for a certificate of appropriateness would have to be scheduled for a later date. So this would really push out the process. In theory, the reclassification, a new hearing for reclassification would come first, and then potentially a hearing on the decision of the actual application before you, though both could possibly occur at the same time. Advantages would be to eliminate any possibility of appeal from NENA. That decision or approved and denied the COA was made upon allegedly unlawful procedure. And the disadvantage is once final decision on the application is made, this deferral and hearing can be used as a basis for appeal by the applicant if the deferral causes the approval or denial of the application to occur more than 60 days from the initial hearing date. And the commission may just deny the application for a certificate of appropriateness. If the commission denies the application, it should provide a very clear and concise reasoned statement of its findings as to why the application does not meet the criteria laid out in code. As noted above, this decision should be forward-looking, as a decision based on prior conduct may be construed as a punitive measure. The advantage of the issue of reclassification would be moot at that point. The disadvantage, likely appeal from the applicant that the decision is arbitrary and capricious, given these plans were previously approved by the commission when proposed with the remodel. So with that, staff at this point does recommend that the commission provide an approval or denial decision on the application. So the recommended options would be to approve DRH 2150 based on staff's analysis and findings, or move to deny DRH 2150. And with that, I'll stand for questions.
Thank you. Are there any questions for Ted?
Madam Chair, and Ted, this is Commissioner Koski. Just clarify for me on the plans that were submitted by the applicant. If I'm looking at those, are those the same plans that were submitted initially for the initial application, and they've gone unchanged except for the status of it being new construction versus renovation?
Madam Chair, Commissioner Koski, these are the same plans that were approved for the extensive remodel, the same plans that came before you last month as well.
Thank you.
Any additional questions before we hear from the applicant? Okay, great. Is the applicant present? Please virtually raise your hand. Great. Please state your name and address for the record. You have 20 minutes.
Steve Vaught, 1924 North Montclair Drive, Boise, Idaho, 83702. And can you hear me okay?
Yes.
Commissioners, thank you for your time. I appreciate you listening to us again. We come before you asking for approval so that the stop work order will be lifted on the property to enable us to finish the construction of the project at 1521 North 5th. The end result is that a home will be built on this property, regardless of the underlying issues or concerns. At the last meeting, no immediate homeowner testified in opposition to this project. The nearest neighbor was Mr. Aldana, who lived 1 block away and spoke as a concerned neighbor and as a builder in support of the project moving forward and the previous history of the property being used by squatters, drug users, and the poor condition of the structure. The present plan fits harmoniously in the area, and to say otherwise would be a tragedy when the project was previously approved by the Historical Commission and the basement, including plumbing rough ends, are completed. Regarding the illegal action of us demolishing the home, we simply refute it as a false accusation. If our intent was to demolish the structure, it would have been done long before incurring tens of thousands of dollars in expenses for lifting the home and paying the additional costs for contractors to work under the said structure. We went through those procedures to preserve the historical structure in good faith. Upon lowering the structure and framing the false support walls to keep the home from collapsing, the true condition of the subfloor was revealed, illustrating its poor condition and being uneven almost 7 inches in some areas. Then, while taking off the roof for renovation, the trusses were crumbling and the home started swaying. It became clear that we needed to take a different approach to the renovation for both worker and public safety. In March, Mr. Vanegas deemed this home a total demolition, despite our preservation of some wall segments to be used after replacement of the subfloor. I would argue that Mr. Vanegas prematurely made this decision. We were then ordered by Mr. Vanegas and Mr. Archibald to clean up the site, remove all debris, and resubmit the project as a new construction, since he said a contributing home was lost. Since the stop work order, we have completed all those items at the city's request, which leads us before the historical district tonight seeking reapproval. Mr. Vanegas and I have exchanged emails regarding our interpretation of demolition and the preservation of property, which led to the stop work order. In addition, we have discussed the bifurcation of the 2 government agencies controlling the historical district having conflicting written opinions. Furthermore, we have agreed that there are numerous ways to preserve the essence of a historical home. Each home being renovated in this district has a different set of circumstances, conditions, challenges, and unknown obstacles that cannot be governed by a blanket set of rules. This project could be the impetus for the immediate need for the city and the historical district to revisit and possibly redraft the entire process and code with more clarity expectations, and possibly removing this bifurcation of the two agencies in the future. And I believe some of the previous prelude to this that Ted laid out has worked on that clarity going forward. Mr. Archibald and the city granted permission to allow site work to reduce the liability of exposed basement by backfilling, finishing window wells, and reducing further erosion of dirt onto the public right-of-ways for the city due to public concern. We have continued to comply with the city's request to complete this. Now we have the North End Neighborhood Association trying to intervene with a retained attorney, asserting that our request be denied due to a new home being constructed, requiring another hearing regarding the conversion of a contributing to a non-contributing status due to the stop work order, and demolition being a possible instant approval tactic to circumvent city code's process. I request that Nina's letter be ignored by the commission for this decision, since Mr. Vanegas at the city instructed us to proceed down this path for reapproval today. We are approaching 5 months since the stop work order was issued, which I contend is hardly defined as an instant approval, especially when I am the person incurring the lost time and bearing the burden of the holding costs of the project. In addition, we have never requested that the home have its contributing status removed, since we deny that the home was demolished prior to the stop work order. If this is an issue now, this is a matter between Nina, the Historical Commission, and the city, not me, the property owner, since I have been following the city's instructions to obtain the reapproval. I simply want to move forward towards a solution where the commissioners will make a decision tonight, allowing us to commence with construction again and not be tabled for another month. As to the underlying issues of demolition and the contributing status reclassification, it simply is not part of the application process tonight. However, I am willing to collectively meet with the City Historical District and Nina separately to discuss and resolve these matters prior to next month, if that will help. I'm truly sorry for the position that we are in today. Our intention was never to demolish a contributing historical home, and ask for your approval of the project again tonight. I appreciate your time, and I'll field any questions that you may have for me. And I am the property owner. I don't know if I disclosed that.
Thank you, Mr. Vaught. Are there any questions for the applicant?
Madam Chair, Commissioner Koski here. I have a question for the applicant. It's regarding the design of the home and the plans. Being that they weren't changed, is your intent to copy the home that was there?
Can you still hear me, or do I have to change a setting?
No, we can hear you just fine.
Our intention is to rebuild the home exactly as the plans show. So we're not changing anything. Whether interior or exterior, we're building it as the plans show.
Okay, thank you.
Thank you so much, Mr. Vaught. Any other questions for the applicant? Great. Is the Registered Neighborhood Association here to testify? Great. I'm seeing a hand raised by Sherry Battazzo. Sherry, you have 20 minutes. Please state your name and address for the record.
Sherry Battazzo, 1110 West Eastman. I'm here alongside Mark Baltus at 1515 North 17th Street. We're here on behalf of the North End Neighborhood Association, Mark as president, and myself as Historic Preservation Commission liaison. We're actually here specifically on behalf of the neighboring residents to the subject property, who, as the owner noted in his letter of explanation, were in an uproar over the illegal demolition of this historically contributing structure that was once located at 1521 North 5th Street. And more than that, not to be seen as just an association, but here on behalf of the neighbors and the owners within the district who do comply with what it takes to remodel and perform construction inside the district. We're all clear that there's value added for constructing a home or remodeling a home or preserving history inside the district, which I suggest is why the applicant selected as location for this project. As we went on record at the last hearing on June 29th, we fully supported the commission's decision to table the consideration of new construction plans that were presented for the replacement of this illegally demolished structure. We agreed that the request for review and approval for new construction plans was unacceptable until an appropriate action has been taken to address the demolition for a contributing structure that cannot be brought back. It was intended to be preserved. Replication is not preservation. The applicant who performed the illegal demolition has provided both written and verbal account before this commission that demonstrated either a lack of understanding or a willful disregard for historic preservation, along with a lack of competency for performing construction that requires preservation. In the homeowner's joint letter of explanation provided on March 25th, they pointed to several areas where a competent contractor may have taken other actions that could have saved the structure. A house that has stood for over 100 years will in fact sway and be on the verge of collapse once its siding, lead-based or otherwise, which serves as shear, has been removed. A house that is disintegrated and torn limb by limb may in fact collapse during elevation to replace upon a new foundation. The record should reflect that countless contributing structures have been preserved during the remodeling process in each and every one of Boise's historic districts for years. Examples include 2113 West Bannock Street, 1017 Residue, 1207 North 15th, 815 North 18th. All of these homeowners went through the cost and the competency to perform these remodels, which involved lifting the home and setting it back down and preserving a contributing structure. While a select few have attempted to cite safety concerns as excuses for the need to demolish a historic structure, this excuse has never been accepted as an acceptable reason for demolition by this commission. It's important to note that, as stated in the homeowner's letter of explanation, reusing good lumber and preserving a subfloor does not capture in any way the essence or intent of historic preservation. Almost equally as alarming as the applicant's disregard for preservation ordinances are the multiple references made at the last hearing regarding the project at 1004 North 15th Street, where a contributing house was also removed in a similar manner and replaced without consequence. The applicant seemed to indicate this as a precedent for actions, and it is for this purpose that Nina has taken this stand. Lack of enforcement is not a defense. It's incumbent upon the city, and I agree with the applicant that uniform enforcement is required for these preservation ordinances that govern the illegal demolition and destruction of historic contributing structures, and by implementing appropriate penalties and consequences for non-compliance. It impacts us all. Lack of enforcement not only reduces the likelihood for compliance, but it diminishes the value that's placed upon areas of preservation. And most importantly, it creates a hardship for the property owners who do comply with regulations and design review process. If you could unmute Mark, he'll raise his hand and continue.
Okay, can you hear me?
We can hear you, but it sounds like there's some feedback.
Okay, I apologize for that. We'll try to correct that on our end.
Everything sounds good now.
Is that better?
Yes, much better. Thank you.
Because I can't hear you guys very well, so I'm just going to go ahead and speak. I don't know how much time I've got left. But as Sherry alluded to in her statement in representing the neighbors of the North End Neighborhood Association, it's really unfortunate that Nina has to find itself in this position of enforcement. We look upon the city to do what we believe is the right thing to do in enforcing its codes. These are not arbitrary laws just put in place and then excuses are made to oversee or make exceptions and that sort of thing. So in this particular instance, especially where there's pointing to a pattern of behavior that in the eyes of the North End Neighborhood Association is becoming prevalent, as Sherry said, the property on 15th, which seems to have set the precedent for bad behavior in this particular case. I want to talk a little bit here about the demolition. As far as I can see, there are two distinct demolitions that occurred here. One was it's just a simple demolition without a permit, as though somebody up on the bench or anywhere tore down their garage and just didn't notify the city of its actions. The other, of course, is the demolition within a historic district, which again is similar but different in that demolition within a historic district, as the commission knows, you have to make findings. You have to make 3 of 5 criteria in order to justify demolition of a contributing home within the district. Now, to say that wasn't the intent of the owner or the contractor is not an excuse, because as he described, removing all the components that would hold the structure sound, and then taking it down for safety reasons, I think is just ludicrous. If anything, that qualifies as demolition by neglect or by negligence, and so therefore is every bit as deserving of prosecution as any other kind of demolition. So it's our recommendation that this be denied, that the certificate of appropriateness for this particular application be denied, because it's an attempt to just ask forgiveness where, you know, asking permission was clearly the right thing to do. I think that there's an opportunity here to through enforcement for the city to make a statement that this sort of behavior going forward is not going to be tolerated. And if the city is not going to, you know, enforce these things in a manner that's uniform and fair, and we want fairness as well as the applicant would want, then Nina will always step in and do what needs to be done on behalf of the residents here who, as Sherry said, play by the rules, go through the review processes at all sorts of additional time and expense and all of that. So if we did not pursue prosecution of these, and these are misdemeanor offenses that carry with them, you know, $1,000 fine. If this was actually if we pursued this through demolition of neglect of historic property, it would carry $1,000 a day penalty for as long as that condition exists. So again, you've got two distinct demolition violations in which to review. And we understand clearly that this is not the job of the commission to designate some sort of punitive action, but it is incumbent upon the city to do what's right. And I think if the commission were to make that recommendation that the city follow through with its enforcement of its ordinances, I think that would be, I think that's important. In addition to this, I just want to make a statement as well, because we're serious about it, that Nina intends to file a complaint with the Idaho Division of Professional Licenses against the contractor for behavior that we think is unprofessional. So that concludes my comments.
Thank you so much, Mr. Baltez. Are there any questions for Sherry or for Mr. Baltez? Okay, thank you so much. Was there any member of the public wishing to testify this evening? Great, I'm seeing a hand raised by Brian Ertz. Please state your name and address for the record. You have up to 3 minutes.
Hi, I'm Brian Ertz. I am the retained attorney by Nina, and I guess I'll do it in this public comment section. My address is 91 South Pitt Lane, Nampa. I just thought I'd give some context as it relates to the reclassification question and the procedural deprivation that's taken place. Normally, if there's going to be a reclassification, or if a structure, object, or value is determined or classified as contributing, there's a process that everyone gets to participate in to debate and make factual findings related to whether or not and to what extent that object or structure should be considered contributing to historic values in the neighborhood. And everyone in the neighborhood, including Nina's members, have a unique and cognizable interest in those factual findings, in those processes, in those procedures. And that's the reclassification process. And so while the staff and or the applicant might be arguing that folks should just look, it's water under the bridge, we don't know what water is under the bridge. And there's a process for that under Boise City Code. That's the reclassification process, where the structure or the remnants or the objects are to be, a factual finding is to be made as to whether or not they're contributing. And so is there subfloor left? Are there walls left? The applicant indicated that they may be interested in repurposing some of those. And there's no doubt we can never get back the historical values that were deprived. there's a factual finding process that Nina has a right to be involved in a hearing upon, through which those factual determinations might be made. Are the walls contributing that remain? Are the walls even still there? The applicant in the application materials indicated that, oh, well, they intended to save the walls, but there's no real mention as, are there any contributing objects or pieces of structure that might still be salvaged and required to be utilized? That's why it's important that the reclassification process be endeavored and that those factual findings be made prior to a certificate of appropriateness determination on an entire new structure. And so I just want to lodge that objection and encourage a denial on that procedural point as well. With that, I thank you for your time.
Thank you so much, Mr. Ertz. Are there any other members of the public wishing to testify this evening? Please virtually raise your hand. I'm seeing Derek Hurd raising his hand. Please state your name and address for the record. You have up to 3 minutes.
Madam Chair, Commissioners, can you hear me?
Yes.
Perfect. My name is Derek Hurd and my address is 112 East 33rd. Thank you for your tireless energy and insight into what you contribute to preserving the character and charm of our historic districts. It does not go unnoticed. I've been designing homes in the historic district for coming on 20 years now, and this isn't the first time someone through ignorance, willful disregard for the rules, or a combination of both has performed an illegal demolition. I think this is a disgrace and a disservice to the neighborhood and to the builders, architects, and designers that do work within the guidelines in these awesome historic districts that we do have. Without strict adherence to the rules or penalties when they were violated, we diminish the value of the whole district. This commission, the city council, and the neighborhood at large must stand up to this wanton disregard for the preservation measures that have been put in place for the benefit of the whole. These are established rules that those working in the district must adhere to. To be ignorant or to not care is not an excuse. Every time the story seems to be the same. We didn't know, we tried really hard, the wind blew it down, on and on. You've heard it all. You guys, some of you have been sitting there a long time. You've heard a lot of those excuses. Some of you are just hearing the excuses for the first time. So I think this builder, future builders, and homeowners that do blatantly disregard these rules need to be held accountable. And for me to best service my current clients and my future clients, I need to know if this commission and the city council is going to back up the rules and regulations. And, many of us are working in this district. It's a disadvantage to us if following the rules is optional. So I'd love to see some teeth behind this from the commission, from the city council. I appreciate Nina standing up and going to bat on this one. Nina's representing 5,000 households in this district, and those of us that are following the rules sure do appreciate that, and those of us that are living in the district sure do appreciate that. So thank you, Nina, for your tireless energy on this effort, and I just wanted to add my voice as a homeowner and as someone who's been designing and creating homes for people according to the rules for coming on 2 decades. So thank you. And thank you again, commissioners, for sitting up there and listening to all these hearings.
Thank you, Mr. Hurd. Are there any other members of the public wishing to testify this evening? Please virtually raise your hand. Okay, I'm seeing none. Josh, are you seeing any? Okay. With that, we'll return to the applicant. You have 5 minutes for rebuttal. Please state your name and address for the record once again. Oh, Mr. Vaught, it looks like you're muted.
Steve Vaught, 1924 North Montclair Drive, Boise, Idaho, 83702. Can you hear me now?
Yes, we can hear you. Thank you.
Thank you for your time information. I've heard Nina's information, which obviously understanding of what went on, which is apparent from their testimony that they provided tonight, because the shear and the siding were on the home, and part of the roof was still on the home when it was swaying and things were disintegrating and starting to collapse. So there is some lack of understanding and a lack of knowledge and some lack of information that they do not have or in the whole process, which is back to my original statement in the beginning. There's going to be a home built on this property at some point in time. I'm not here to say what happened was right or wrong. I mean, I'm truly sorry for what happened. I'm an unintended victim. I hired a contractor to do a job. Obviously, it hasn't gone right. Just trying to move forward as the property owner to get the thing completed so that I can have a home to move into in the near future. The underlying issues of the demolition and this reclassification that I never requested, never asked for, and I believe Ted brought to the attention that I don't know if a public hearing or something needs to be said on the issue because no home issue is there now. We were ordered to haul off all the debris in that, so no wall segments exist. Some old dilapidated 2x4s from the subfloor are there. We preserved the sandstone foundation blocks because we did want to reuse them. They don't make that type of product anymore. That's a historical product. We want to reuse it. So I know this process and I know what's happened now, and I am truly sorry, but the underlying issue of the appropriateness of the home and that on the application at hand, that's what I'm hoping you'll approve so that we can continue down that path. And like I said before, I'm willing to meet with everybody regarding the two underlying issues, and I don't want this to become a long, protracted legal matter, but those are underlying issues that are going to be resolved at some point in time, but a home is eventually going to be built on the property. That's just a fact. At some point in time, it will. We've already started the process. The foundation is in, the roof and plumbings are in, the structure needs completed. If anything, if it's going to be a long drawn out process, the basement should still be framed and a subfloor put on to cover up the 9 foot hole in the basement, because I believe the basement has 9.5 foot ceilings. So things need to be tidied up and finished. A home needs to be built. And I know we can work through these other matters, whether, Nina, regarding, there needs to be there needs to be things done. Let's work through this issue and find out what we can do together so this process doesn't happen again. And other homeowners who are hiring contractors don't have to sit here like I am today to go through this. It's not fun. And trust me, it's been long. And I'm looking forward to putting this behind us, but it's going to take a long, long time. So I hope you vote in favor of getting this done tonight. And I am truly sorry for us all being in this position.
Thank you, Mr. Vaught. Are there any final questions for staff or for the applicant before we have some discussion? No? Okay, great. So with that, I will go ahead and close the public portion of the hearing. I think, just for the sake of the complexity of this application and situation, that we should just jump right into discussion as opposed to entertaining a motion right off the bat. And I will say, I think this is the trickiest application I've ever seen in my 5+ years on the commission, this is really tough. So I do want to remind my fellow commissioners that the plans that are before us tonight were previously approved back in 2017. That is what we're looking at, and that we as a commission are not legally in a position to be punishing applicants. It's our job and responsibility to be hearing the application before us tonight. So with that, I'll go ahead and open up some discussion from my fellow commissioners.
Madam Chair, Commissioner Richter, I'd just like to make a really clear clarification. The application and the plans that are put before us tonight were drawn based on a remodel of a contributing historical structure within the North End Neighborhood Association. The plans that are set before us tonight are not of new construction.
Correct.
So I will make that comment, and I would like the discussion to go on further and see where it goes.
Thank you so much for that comment. Does anyone else have additional comments?
Madam Chair, this is Commissioner Koski. I do feel it's appropriate to have a motion, a second to offer discussion, but I do understand the gravity of this topic and the application in front of us. I think that while the application is for the new construction being built on top of this existing foundation that currently has a stop work order for violation of code, and that the stop work order was issued by code compliance or code enforcement. And if we are going to approve or entertain approving this, we are in effect operating in a way of enforcement or penalty or lack of. I agree that as a commission, we do not, it's not our job to worry about enforcement or penalties. So I am struggling greatly on approving something for a project that has a stop work order because of illegal activity. I disagree greatly with the testimony from the applicant that they were saving items to reuse in wall sections, because I was there the day it was demolished and saw that. And if we go into public record, there will be photos of the demolition when the complaints that were issued for demolition, and those photos will show that demolition was done without approval. This applicant has stated and has shown that they knew they could not demolish it because of the acts because of the work they did to raise it and lower it and try to keep it. They've shown that they know it could not be demolished and that they knew of the procedures to go through to get approval. They knowingly did not do that. And now, by their application for a new structure, they are trying to say, oops, sorry, and move on. I understand the homeowner's position in that this is a long time and he wants a house. I get that. I also know that we shouldn't be, as a commission, our job isn't penalty or any kind of punitive action against him. That is the job of city council and the mayor. That is the job of our city. We can't do that as a commission. I would like to see the applicant appeal a denial to go in front of city council and the mayor to explain to the city council and the mayor why and how they went against the demolition. And for this reason, as well as a couple others, but for this specific reason, I would like to move that we deny this application. And with a second, and now let me restate that. I'd like to move that DRH 20-00150 that we move to deny. And with a second, I would like to offer up some more discussion. Thank you, Madam Chair.
Thank you, Commissioner Koski. Do I have a second?
I could second it for some discussion.
Okay. Thank you, Commissioner Richter. Let's further that discussion before we call the roll on that.
Madam Chair, Commissioner Koski, thank you for offering more discussion. I think it's really important that all of us as commissioners chime in on this. This is something that I'd like to see resolved quickly so the homeowner can move on. I mean, we're not about delaying the homeowner's ability to move forward. We're about making sure that the rules are followed and so on and so forth. I do want to state that one other thing that should be looked at and reason for denial would be that in Chapter 5 of our design guidelines, it specifically stated that it is preferred to design congruous contemporary structures rather than duplicate or mimic the design of historic buildings in the district. It's been made clear in testimony today and through the plans that this is a copy of the historic structure, an exact mimic of the historic structure. And we have to go by, as a commission, the Secretary of Interior standards, and as stated in Standard 9 of the National Secretary of Interior standards, it does state that new construction should also be distinct from the old and must not attempt to replicate historic buildings. The Secretary of Interior does advise that replication and mimicry are unacceptable approaches to design. So as far as merit for denying the existing plan, I believe there's full merit in that should be redesigned. But more importantly, I really would try to encourage the applicant to be in front of the mayor and city council to face, to help us as a city and to help the applicant understand what the consequences are of breaking the rules. Thank you, Madam Chair.
Thank you, Commissioner Koski. Do any of my fellow commissioners have anything they'd like to share?
Madam Chair, Commissioner Richter, I'd just like to say that Commissioner Koski pretty much nailed it on the head there, and I definitely agree with every point that he made. So, thank you.
I concur. So with that, if no one has any additional comments? No? Victoria, will you go ahead and call the roll on that motion, please?
Montoto,
Aye.
Rupp, Koski,
Aye.
Maroney,
Aye.
Weaver,
Aye.
Richter.
Aye.
All in favor, motion carries.
Thank you so much. The next item we have on our agenda this evening is DRH 20-00231, James Byron at 1417 East Franklin Street. This is a certificate of appropriateness request to demolish an existing one-story garage and to construct a two-story garage with accessory dwelling unit in an R-1CH. Ted, can we please have the report?
Thank you, Madam Chair, members of the commission. This, as stated by the chair, a certificate of appropriateness request to demolish a garage and to construct a two-story garage with accessory dwelling unit. Site's located at 1417 West Franklin Street. You can see the lot highlighted in pink on this slide here. The applicant has provided a before and after site plan. So the top is the existing conditions and the bottom is the proposed site plan. As proposed, the project will meet setbacks required by the zone. However, the backup space from the doors of the garage, I believe, are not 25 feet. There's 22 foot of backup space plus 3 feet of buffer space for a total of 25 feet required from the doors of the garage. So if approved, the applicant would either need to redesign to meet that extra 3 feet from the door or apply for a variance. These are the elevations of the garage and ADU. The peak height is about 18 feet. And then some renderings. And then here's some photos of the existing structure in the house. The house is a 1-story. And then some of the garage, and you can see some of the neighboring structures in the background. And then here's a view along the alley. As you can see, there's some different structures along the alley, different size structures along the alley. We did receive some public comment on this. We had one comment opposing the project due to the height. We had one comment in support of the project, and then we had the applicant provided a petition with signatures from the neighborhood in support of the project. Potential areas of concern, proposed lot coverage is about 38%. So the existing garage contributes about 7% to the lot coverage, and the new garage contributes about 9% to the lot coverage. So about a 2% difference there, approximately, in lot coverage. The height of the proposed garage will be about 4 feet taller than the non-contributing house. So again, the peak height will be about 18 feet, which is relatively modest for garages with ADUs above. And additionally, the house is non-contributing. So we've discussed this in the past where there's a garage ADU that's going to be higher than the house. When the house is non-contributing, potentially that non-contributing 1-story house could be changed. It could be increased in height. Another story could be added onto it. It could be demolished someday and rebuilt with a taller house. So with a relatively modest peak height of 18 feet and the non-contributing status of the house, the staff did not add a condition of approval requiring that the garage be shorter than the house due to some of these issues explained here. And with that, we recommend approval of DRH 2231 with the recommended conditions of approval in the staff report. Thank you.
Thank you. Are there any questions for Ted?
Yes, Madam Chair and Ted, this is Commissioner Koski. You mentioned the of the new building in relation to the house and being taller, and that the house is non-contributing, so it could be up for additions on a second story. Do we have photos of the homes on either side of this property, and are they 1 stories? Are they 2 stories? Are they story and a halves? Do we have a picture of a street view?
Madam Chair, Commissioner, I believe the house right next door is a 1-story house, and I think the house to the other side, to the west side, is a story and a half. So you have a 1-story and a story and a half structures adjacent.
Okay, thank you.
Any last questions for Ted before we hear from the applicant? No? Okay, great. Is the applicant present? Please virtually raise your hand. Oh, she's here. Please come forward, state your name and address for the record. You have 20 minutes.
Okay, Madam Chair, I'll bring up the applicant's presentation and then work through the slides.
That would be great.
For her.
Okay. Good evening. My name is Krista Stumpf. My husband, James Byron, and I are the applicant of 1417 East Franklin Street. Just for that clarification, I believe Ted's presentation said West Franklin.
Oh, thank you.
Oh,
and when you're ready, Ted.
Okay.
Okay. Thanks for hearing me tonight. You can go to the next slide. I wanted to point out the unique position that our home is in. We purchased the home in 1998 because it was a historic home, although the district didn't exist at the time. In the early 2000s, when the district was formed, I actually opted in because I think historic preservation is important, and I had hoped that some of my neighbors on the street would have done the same. But so I'm the funny little square in the East End that everyone asks about. In 2011, we actually remodeled the home and worked very hard with staff and the Preservation Commission to do so in a way that we felt was added to the historic nature of the home. And so here today in 2020, we're submitting a plan for a garage and ADU. Next slide. So I just have some pictures. Actually, the assessor came by after we had remodeled, and brought us that picture from the 50s, the home in 1998 with the garage. And you can see even at that time next door, there was quite a tall structure there. And then today with our house and garage and pandemic swimming pool this summer. Next slide. So I wanted to just hit on our proposal. These are similar to what we submitted in the package, but just a couple of key points. So the proposed garage is about 3.5 feet taller. The pitch of the house is 14.5 feet. And we worked really hard to make the structure as low as possible and still be usable. So we kept the side load, an 18-foot roof line. It provides 23 by 26 feet with interior stairs and the 38% lot coverage. So it offers an ADU of about 365 square feet. I have a couple of other pictures. Next slide. So in this image, we're trying to show that, and this was my largest criteria, that from the sidewalk view, the garage did not overwhelm the existing house. And I think we've done a pretty good job there. You can see what that would look like. And then we have a couple other images. Next slide. So you don't see the front door here, but our architect worked these up. So standing at the front corner of our house, that's the view from the sidewalk, the west side. You can just see the structure in the back. Next slide. Here's the side of the house. And so you can see that this actually you probably wouldn't be able to see from the sidewalk because of course this is in our backyard here. Next slide. Just a couple more. This would be from the alley view. This is what you would see. And next slide. And the other corner of the alley view. So next slide. So just to hit on a couple of things, originally I actually was aiming for a remodel of the garage, but it has a really shallow foundation and the wood is touching the dirt. And I think it would end up being that one post was maintained there. So we wanted to keep the side load, and we did experiment with some others. Right now, as it's designed, as Ted mentioned, there's 22 feet of maneuver space. And so we will have to apply for a variance. The setback, so the garage is currently on the property line and the alley, and we would set it back the 5 feet as proposed here. And the roof line is lower, and I'll show you some photos of surrounding structures on the alley and some of the homes on Franklin and Washington. And again, we just worked really hard on the mass of the garage. In terms of lot coverage, this is something that's also important, and I think I've testified on this matter, but we are in line with many other homes in the East End that have been approved. And again, we worked really hard to keep this a small space. And then of course the ADU provides additional housing and off-street parking. Next slide. Okay, so I'll just go quickly through here, but we worked, like I've said, we worked really hard, and these are actually, we hired a different architect, and then our current architect came up with some alternative plans. So this was the first plan, which you can see has a 7.5 foot difference in the house. We don't have to linger here, but I just wanted the commission to know that we gave it a lot of consideration. And so this next, this is the same, just different elevations. And then this was done by our current architect, but still shows the exterior staircase and something that's quite common in the East End and North End, this kind of box in the back. And so we didn't feel like that met our needs, even though it would give us actually more space. Next slide. And so that's the front elevation of what could have been. Next slide. Okay, and we did want to get support. And so the East End Neighborhood Association, I believe, submitted a letter. I talked to Sheila and she was supportive of the project. And then we contacted all the neighbors on the alley, so on both sides of the alley. And only one was concerned about the height, as Ted indicated. And I'll show you that her home behind us is taller. So that's the next slide. So this is kind of a funny picture, but if you see on the left side of the slide, 1422 East Washington, that house height is 20 feet 8 inches. Our neighbor's garage, 1415 East Franklin, is at least 19 feet tall. Of course, our house is 14.5, and we're proposing 18 feet there. But, and then this is from Haynes Street walking towards Costin, and you can see there the blue home, or the blue garage and home, are quite a bit taller. And if you keep going, next slide, down the alley, you can see that that home right there by that garage on the first picture is the Boise Boys' new house, and that's a very large home. And then moving towards our house, that's 1415 East Franklin, which again was taller than our home. And so just a couple more pictures of what's existing. Thank you for your time.
Thank you so much. Are there any questions for the applicant? I have to say, I loved those pictures. That was so great that you were able to get a hold of that in 1950s. That's awesome.
Madam Chair, I do have one question.
Sure.
Just out of curiosity, I know you did a remodel on your house. Did you, in the past, have you done any other additions on it, or is the garage kind of the first exterior work you've done?
Other than the remodel, thank you for your question. Other than the remodel in 2011, which did add on to the home, we have not made any other changes.
And do you, by chance, I'm sure it was in there and I just didn't see it, what is your lot size? What's the size of your lot? Do you know that?
Shoot, my husband would, he's on the phone, but
that's okay.
It's not substandard. It's a standard East End lot, but I know they're all different, maybe 55.
Madam Chair, it's in the packet. It's
yeah, I know. I just didn't remember.
6,100 square feet.
6,100.
Okay, thanks.
Which makes it a standard sized lot.
And then I wanted to piggyback off that question. Do you have plans in the future to do any additional exterior remodeling or adding a second story on the main structure?
Not at this time. You know, it's hard to predict the future. Actually, in 2011, when we worked on the remodel of our home, we considered a second story, and actually working with Trout Architects at the time and the city staff, they discouraged that. And I realize things are different now. So while Ted has a point, and that's something we could consider or a future homeowner could consider, we don't have any immediate plans. You won't see me back in a year.
Great, thank you so much. Any final questions for the applicant? Okay, thank you for your time.
Thank you.
Let me pull up my preamble here. Is the Registered Neighborhood Association here to testify this evening? Did we have a letter from Ina?
Madam Chair, I didn't receive a letter from
You didn't
Ina.
receive one.
No.
Okay. I'm not seeing anyone. Are you seeing anyone, Josh? No? Okay. With that then, is there any member of the public wishing to testify this evening on this application? Please virtually raise your hand. I'm not seeing anyone. Josh, are you seeing anyone? Nope. Okay. Are there any last questions for staff or the applicant?
Madam Chair, this is Commissioner Koski. I have a question for staff. While I'm posing this question, maybe pull up the East End district map that shows a little bump out of what house she has. The question I have for staff is, since this house is on a street without, as the only historic district home there, is the lot coverage and setbacks required by planning and zoning in the city the same for the non-historic sites on either side of her and across the street from her? Is it still 35% and the 25 feet required for a garage backup?
Madam Chair, Commissioner Koski, there isn't a lot coverage maximum for non-historic properties. If it's a substandard lot, there are substandard lot rules, and it has to comply with our substandard lot ordinance, which I think the corner house, it's not in the historic district, but I believe it's a substandard corner lot. So it would have to comply. It wouldn't comply with lot coverage. That wouldn't be a thing for them, but they would have to apply with the maximum floor area ratio for substandard lot. They would still have to comply with the standard 22 feet of backup space plus the buffer area. That's city code, which is why you would need a variance to reduce that. So, but as far as lot coverage, as far as restrictions to height of a detached accessory structure, they wouldn't have to comply the same way.
Okay. Any final questions for Ted? If the applicant would like to come forward, you have 5 minutes. You don't have to yield it if you don't want to, but just state your name and address for the record one more time.
Krista Stump, 1417 East Franklin, Boise, Idaho. And I don't have any further remarks. Thank you for your time.
Thank you so much. With that, we'll go ahead and close the public portion of the hearing. And I will consider a motion prior to some discussion.
I'll go ahead and make a motion before discussion, and then we can have some discussion. But I move that we approve DRH 20-00231 with staff's recommendations.
I'll second that.
We have a double second. I think I saw Commissioner Maroney first. But I am open to any discussion. Commissioner Weaver, if you want to start out on that.
Yeah, I actually have, I think that the height is fine in my opinion. I think the garage is set nicely behind the house, and I agree with one of the renderings that showed that you would barely see the house or the garage behind the house. Yeah, it was actually I think the next one, but it's okay. It looks really good. And I really appreciate the owner's willingness to try and work to make the garage compact and as low as possible. My only concern was really the lot coverage. And part of the reason why I had asked about additional remodels was because of the fact that they've done a remodel and maxed out the lot coverage already, and now we're adding on more to it. So, you know, it kind of keeps chipping away at it. But I appreciated Commissioner Koski's questions about the other parts of the neighborhood and if they would have to comply if they hadn't done what they did. And I think in my mind, it's probably more important that they wanted to keep their house and put it in the historic district than probably the lot coverage, because I would imagine that there is probably a lot tighter lots around them than what they're doing here, which is why ultimately I decided that I would approve this.
Thank you so much. Any additional discussion?
Yes, Madam Chair and Commissioner Weaver. This is Commissioner Koski. I applaud the applicant, and I wish I could see you and wish I was in front of you to say I applaud you for opting in to be part of the historic district when it first was put together. And that little overhead map kind of tells the story of your commitment to preservation and to the different things that the historic districts are all about. So I applaud that, and I think your design is great. I was and I guess am a little concerned about the height being above that of the house, being that you don't have, I mean, you don't have taller houses or garages on either side of you. And actually you did have some in taller height, but you don't have 2-story garages on either side. But the fact of the matter is your neighbors aren't part of the historic district. So my concern about the height, I think, has been taken away. I think you've done a great job, as Commissioner Weaver said, to limit your height, and with that, you've gone over the lot coverage of 38% to 38% from 35. I'm a little concerned about that, and I'm concerned about the 25 feet of space for the garage. I'm willing to overlook or approve the lot coverage based on where your lot is and who your neighbors are, and that they aren't held to the same standard. But my concern, I guess, is the 25 feet, which is required for the backup space of the garage, including the buffer. So my thought is to approve this, but with concern that you can get that handled through a variance or through other means.
Madam Chair, Commissioner Richter, I appreciate my fellow commissioners' comments, and I do appreciate the energy and effort that the applicant has gone through in order to put together a hopefully viable project for them. I think the design is good. The three things that we're talking about is height, massing, lot coverage, and backup space. I think we all know where I stand on garages being subordinate to houses, so that's one thing I have a pretty big problem with. And also with lot coverage. Backup space, I don't have that big of a problem with because it's a variance that can be taken care of through other means. So although the design is good and the intent is there, I don't know if I could approve this application with that with the peak height exceeding the existing home and lot coverage exceeding 35%.
Thank you, Commissioner Richter. We do have a motion before us. Is there any additional comments before we go ahead and vote on that?
Madam Chair, I have a additional question for Commissioner Richter. Again, lot coverage concern of mine. Also, if Commissioner Richter, do you think if a condition of approval was put in to reduce the size of the garage to meet the 35% lot coverage, which I would imagine then also put them in a position to meet the backup of 25 feet, including the buffer, would that be something that you would be more likely to approve, or is the height still something too significant?
I think the lot coverage is probably a Madam Chair, Commissioner Richard, thanks, Commissioner Koski, for the question. I think the lot coverage is definitely a little bit more of a concern of mine. The peak, although it is higher than the home, we've seen applications where the peak is considerably higher than this, and the way it is designed, like I said, I do appreciate how it is designed and where it's located on the lot. I could possibly overlook the peak height. That's not in my favor, but I think if the lot coverage was reduced, I would be agreeable to approving the application. I don't know if it would be a usable garage at that point, though. That may be my only concern.
Okay. Does anyone have anything further before we go ahead and vote on the motion before us to approve the application?
Madam Chair, Commissioner Koski, I guess would wonder if I could get Commissioner Weaver's comment on possibly amending your motion to include lot coverage be reduced to 35% and the driveway backup space to equal 25 feet, including the buffer.
Well, I guess my thought is on that is that I'm kind of with Commissioner Richter that I don't know how usable that garage will be in if you can just cut off that. I guess what I would prefer, if that's your choice, is that you deny the application and then have them come back and rethink how they are actually going to design it, rather than just asking them to chop off some amount to it, because the garage that was there before made it right at the the 35%. So they don't really have a choice of, as far as I can tell, of anything they can do. So I guess I would prefer to go ahead and then if you just would go ahead and deny it with with their understanding that that's the reason for denial, and that they go back and think and come back with a new proposal for us.
I do want to share my thoughts, I think. Ted, do you mind going back to the map of the historic district? Thank you. So basically all of the surrounding properties, not on the alley side, but to the north and to the east and to the west, are not a part of the historic district. So, and like the applicant said, they opted in, which I think is fantastic. And I think we can see their appreciation for their historic elements that they've maintained in the remodel and in this design as well. They're already, if this application does get approved, they're already going to have to get a variance for their garage, which all of their neighbors are not held to that same standard. So my thought process is, I see that there's a little bit of wiggle room here in this application. And so I will be voting in favor of this. But that's just kind of my thought process, and I wanted to have that on the record. Are there any additional comments before we go ahead and vote on the motion before us?
Madam Chair, Commissioner Maroney here.
Hi, Commissioner.
I just wanted to say I agree this is a unique situation, and usually I vote against if it's taller than the house, and I'm a pretty big stickler about lot coverage. But given that kind of the purpose is to maintain the character of the historic district and of the blocks that these houses are on, and knowing that the rest of the houses on the block that this house is located on can change, I find it really admirable that they've opted into the historic district already. They've gone through several redesigns trying to meet our standards that their neighbors aren't going to have to do. And so I will be voting in favor of this project.
Thank you.
Madam Chair, Commissioner Richter, I appreciate that all the comments the commissioners have made, including yourself. And just to say this, they did opt in. They know what the guidelines are, and the home and property should be designed under the guidelines.
Thank you, Commissioner Richter. Victoria, can you go ahead and call the roll, please?
Montoto,
Aye.
Rupp,
Oh, I don't think we heard you, Commissioner Rupp.
Aye.
Weaver,
Aye.
Richter,
Nay.
Maroney,
Aye.
Koski,
Aye.
5 in favor, 1 opposed, motion carries.
Thank you so much. And with that, I will adjourn the meeting. Thank you everyone for your time this evening, and we will see you next month.
Thanks, everybody.
Thank you.
Thank you, everybody.
You have a nice night.